Hello, this is Sarah Brash. Welcome back to my channel. So I want to do a video. I'm probably going to end up doing more than one video on this topic because I don't want this video to get too long. But I want to talk about the Anti-Semitism Awareness Act. This is a bill. It has passed the House. It's going to the Senate next. And it's a really bad, horrible bill, extremely violative of the First Amendment, and this is not the way. This is not the way. This is not the way to combat anti-Semitism and Jew hatred, especially on college campuses. This is not the way that we defeat the woke DEI and CRT industry. It's just not. It's not the way. It's not the way forward, and it's not the way to defeat the pro-Hamas mobs on college campuses that are terrorizing Jews. We have to maintain our principles. We have to maintain our Enlightenment principles, our civil liberties, our commitment to civil liberties. We have to maintain our principles, or else all is lost. There's no reason to continue fighting for our democratic republic if we don't maintain our commitment to civil liberties. And I am a hardcore civil libertarian. I have put my career on the line to defend civil liberties. So this is not the way forward. But so the Anti-Semitism Awareness Act, it's a bipartisan effort. It's well-meaning. Part of the bill, which is simply recognition that Jews as a community are also an ethnic group with shared ancestry that should be covered and protected by Title VI of the Federal Civil Rights Act. You know, that part of the bill is fine. It's basically just acknowledging that fact, which is something that, you know, is just simply a true statement that Jews are an ethnic group with shared ancestry, so of course they should be protected by Title VI of the Federal Civil Rights Act, as white people should, as everyone should, because we should be applying Title VI of the Federal Civil Rights Act in a colorblind manner. We should be using it. That is the way to defeat the woke DEI and CRT industry in academia. But the problem with the bill is that it is grossly violative of the First Amendment. And so what has happened is that, like, Chris Rufo has written a piece in, basically saying what I have just said about the bill, that it's not a good bill, that this is not the way forward, that it's violative of the First Amendment, and that it basically, applies, a quote-unquote hate speech analysis to Title VI of the Federal Civil Rights Act, which is exactly what we don't want to be doing. Because hate speech, this is something that I have to address repeatedly, but people are still under the gross misapprehension that hate speech is not free speech. Hate speech is 100% free speech. And, I got in no small amount of trouble during the witch hunt at Yale for my essay that I had written with the title that, I considered my catchphrase, which is that I love hate speech and I hate hate crime legislation. So that was good that Chris Rufo, that piece it's very good, it's very apt. And like the biggest problem with the bill is that, well, it's twofold, but the biggest problem with the bill is that it incorporates, it codifies the definition of anti-Semitism that is employed by the International Holocaust Remembrance Alliance, IHRA, and it is a definition of anti-Semitism that says that gives examples of statements that are definitively anti-Semitic. And one of those statements is saying that, that the state of Israel is in and of itself a racist endeavor. And clearly that's a statement that if you made that statement, it's protected free speech under the First Amendment. And then also another statement that I in particular noticed was that criticizing the policies of the state of Israel and comparing them to Nazis, to the Nazi policies of Nazi Germany. And that's obviously also a statement that would be completely protected as free speech under the First Amendment. So that is, that in and of itself is problematic. So there is a professor whom I esteem greatly and love and respect, and his name is David Bernstein, and he wrote a National Review article actually in support of the Anti-Semitism Awareness Act, or AAA. And he basically said, look, everyone's all up in arms. People like, Robbie Suave are saying that this, criminalizes, what should be considered completely First Amendment protected, constitutionally protected free speech statements, like the two that I just mentioned, and that this criminalizes that speech. And so, David Bernstein said this is ridiculous. He says, first of all, it doesn't criminalize anything because it's not a criminal law. It's a civil law. It's an administrative law. But of course, the First Amendment doesn't say, Congress shall make no law abridging freedom of speech. It says, or it doesn't say Congress shall make no criminal law abridging the freedom of speech. It says Congress shall make no law. And then this is the topic for another video, but once you start talking about significant punitive damages that are part and parcel of civil law, then the boundary between civil and criminal law becomes, very fuzzy. So, that's neither here nor there as far as I'm concerned. But you can make the argument, which I did to Professor Bernstein, that it outlaws. It in essence outlaws speech that's completely protected under the First Amendment. And so the other argument that Professor Bernstein has is that, well, look, sure, this is in some respect, in some minimal, nominal sense, for this very narrow purpose, you can consider it, and he would probably reject this phrasing, but that it's constraining. We'll say constraining. He would probably go along with that. Constraining speech that's completely free speech protected by the First Amendment of the U.S. Constitution. And so, but he would say that it's only for this very, very narrow purpose of Title VI under the Federal Civil Rights Act, for, determining that we already use speech as evidence for discriminatory mental intent, right? So that's his argument, is that we already do this. We already do this employing the IHRA definition, so that this bill is, a big nothing burger because it's just codifying the status quo, and it's just for this very narrow purpose. And we already constrain speech because we use, in some sense, in some manner, because we, this could have a chilling effect on speech because we do use speech as evidence for discriminatory mental intent in determining Title VI federal civil rights violations. But the other problem that I pointed out to Professor Bernstein, and we corresponded on X about this a little bit, is that that's actually not what the Anti-Semitism Awareness Act says. The Anti-Semitism Awareness Act explicitly says that these statements, like the ones I mentioned, that, you know, Zionism is racism, that these statements that are completely protected in the First Amendment, that they are being used as evidence for motive, that a violation of Title VI of the Federal Civil Rights Act was motivated by, you know, racism, by anti-Semitic racism, by Jew hatred. And so the huge problem with that, I don't want this video to get too long. I'm going to make more videos on this topic, is that, and this is something that I've talked about, you know, a million times, and we'll probably talk about again another a million times. The big problem with that, and I've talked about it extensively in the context of the Karen Acts, a brazen new form of hate crime legislation, is that yes, we can use speech, and we do use speech as evidence of mental intent. And mental intent is not motive. Motive and mental intent are two very different things. Mental intent means that you did something intentionally, you intended to do it. And in the context of criminal law, that is, you did it on purpose, you did it knowingly, you did it recklessly, or you did it negligently. And that is a completely different thing than motive. So motive is why you did it. Motive is, you know, you did it because you hate Jews. And so that was your motive. That was your motivation, right? And that's why in the context of the Karen Acts, this is a brazen new form of hate crime legislation, because before the Karen Acts, there had never been a piece of hate crime legislation where they weren't at least pretending to abide by the US Constitution, by the First Amendment. And so what they were doing, they weren't explicitly criminalizing motive, but with the Karen Acts, they're explicitly criminalizing motive. So it's like, you're not even pretending that this isn't hate speech, speech and thought crime, you know, hate speech and thought crime. And hate thought crime. So that's why you have to make a distinction between motive and mens rea, or mental intent. And that's why the Karen Acts are a brazen new form, because before the Karen Acts, they were at least pretending. They were pretending that they were abiding by the Constitution and that they weren't criminalizing motive. So they would do the determination of whether or not that it was the sentence should include, you know, a provision for hate crimes occurred after the determination that they were guilty of just the crime without criminalizing the motive aspect, the racist motive aspect. But now with the Karen Acts, they're just criminalizing motive. There's just no ifs, ands, or buts about it. They're just criminalizing motive. So that's really egregious with the Anti-Semitism Awareness Act, because it's not saying that we're going to use speech as this evidence for this very narrow purpose of determining mental intent, that you intended, that you intentionally, that, like, say a university intentionally discriminated against someone based on race. That's not what the Anti-Semitism Awareness Act says. It specifically and explicitly says that we are using these statements, including these statements that are completely protected free speech under the First Amendment. We're going to use these statements as evidence. These statements are going to be definitive, dispositive evidence of a racist, anti-Semitic motive. And that's just straight up thought and speech crime. And if you don't want to say crime, because it's not criminal law, it's civil law, you can say that it's, that it's outlawing that speech. that it's a ban on that speech. I mean, it's more than just saying, well, oh, it'll have a chilling effect. No, this is more than that, because once you say motive instead of mental intent, then this is an outright, this is a legal curtailment of speech, you know, an abridging of speech. It's a legal abridging of speech that is unconstitutional under the First Amendment of the U.S. Constitution. I don't want this video to get too long. I'm going to make more videos on this topic, I promise. But just know that the Anti-Semitism Awareness Act, it's bad. It is a bad law. It should not become law. And we'll talk a lot more about this. Okay. I'll talk to you all later. Okay, I'll have all my fundraising links below, and please donate to my fight for justice, and I will talk to you soon.